Mr. Foote. Who is with Mr. Foote?
Hi, I'm his wife. My name is Dakota Hendren.
What's your name?
Dakota Hendren.
Dakota, and can you spell your last name, please?
Henren.
Okay. Did you get that? It's Dakota, and it's Hendren, Hendren. All right, and I apparently I have Jerry Cook apparently by phone. I don't have video, but she needs to start the video. Can Washburn County hear me?
Can, Your Honor.
Excellent, thank you. Just give me one quick second and then we will get going.
Judge, can you tell me who the court reporter is, please?
It is Corey. Now I can't think of your last name. Jeske, I know it.
Thank
She's
you.
fairly new and I just call her Corey. It's K-A-U-R-I-E.
I got her. Thank you.
All right. Okay. We will go on the record in the matter 18 FA04 in re the marriage of Heidi Foote, now known as Kneffelkamp, and Tyler Foote. We have appearing all by video conferencing. We have Heidi Kneffelkamp with Jerry Cook. We have Tyler Foote with Jennifer Brown. We have his wife, Dakota Hendren, also appearing, observing. We're set today in this matter for, I believe it is a hearing on the motion for a protective order. Ms. Cook has also requested, I believe, that the court hear a motion on the notice to compel discovery. I believe that is all we are covering here today. Is that correct, Ms. Cook?
Your Honor.
Anything you want to add, Ms. Brown, before we begin?
Just, Your Honor, that the discovery motion was just proposed yesterday. So I understand that we're here today, but in terms of the content being given proper notice, I don't believe that has met the notice requirement.
It hasn't met the notice requirement, and I'm going to take your statement as you're not waiving the notice for argument today.
That's correct.
All right, so I won't hear that matter for today's purposes. We're here for the motion for the protective order. Ms. Cook, you may begin.
Thank you, Your Honor. On October 16th, we were served with the respondent's first set of interrogatories, request for production of documents, and request to admit.
Ms. Cook, I am just going to ask you to politely speak slower.
Yes, Your Honor. After we were served on the 16th of October, we responded in a timely manner, and we responded on November 7th of 2024. But before we responded, we moved the court for a protective order, and we would like the court to issue such an order requiring that discovery in the matters that we asked for protection for not be answered. Specifically, 4 of the interrogatories and their subparts, 10 of the request for production of documents, and 2 of the requests to admit. Beginning with the interrogatories, the first interrogatory, we have an objection to our interrogatories 9 and 10. They asked my client if she knows 3 individuals who are not connected to this matter in any way. They're not witnesses, they're not parties, they just have no earthly connection to this matter. And then she's being asked to write an introspection telling her ex-husband why her relationships failed. This is a great emotional burden on her, not to mention a time-consuming burden. It often takes people years to figure out why their relationship fails. And again, this has no connection to the matter at hand, none at all. The only issue here is whether Mr. Foot's current behavior poses a present or future danger to his adopted daughter, not Ms. Kneffelkamp's past relationships. Regarding interrogatories 11 and 12. In these, the respondent is asking my client to search all media platforms for what in 3 short weeks will be 5 years of posts, trying to see if she ever posted a video directed at Dakota Hendren or other partners of Tyler Foots. My client has no idea if such a video exists, and it would take her quite a while to locate them if she could after 5 years. Some of these accounts have been closed for 2 or 3 years. There's no way for her to find this information. And again, it poses a great burden on her, not only emotionally and time-wise, but we would have to find an IT professional to help us recover these. There's just no way to recover them, and we're not quite sure what they're referring to begin with. Regarding the production for documents, and we objected to 10 of those, and all of those begin with the same objection. These are requests for electronically stored data that are years old. None of them are even asking for anything recent. Anything referencing Tyler Foote in any capacity from January 1st, 2021 until now. My client doesn't have access to that level, that deep dive of social media posts. She has no way of knowing which ones he's talking about, if they exist. And it would, again, cause a great time-consuming burden on her. And because of the length of time that has expired, we would have to hire an IT expert to try to chase these things down. The same for request number 3. They're asking for any social media posts, including videos, referencing Mr. Foote's significant other, Dakota Hendren, in any capacity since January 1st, 21 until now. We don't even know if they exist, where they exist, and we certainly have no way to search through almost 5 years of copies of social media posts and referencing Dakota Hendren. We're not quite sure what the purpose of this is, and it's just not relevant to this matter because there's only one issue before the court right now, and it doesn't involve Dakota Hendren. Again, request number 4, text messages between Dakota Hendren from January 1st, 2021 to present, where you discuss concerns for the children while in Tyler Foote's care. My client does not save text messages from Dakota Hendren. She just doesn't have them, any of them. And once they've been deleted, the only way for us to get them are to inquire with her provider or hire an IT professional. Request number 5, it's the same issue, Your Honor. It's a large chunk of time. They're asking for a true and accurate copy of all text messages between her and Tyler Foote. Again, my client doesn't keep these text messages. If there are any in our family wizard, Mr. Foote is free to let us know that they're there, but my client doesn't have them, doesn't know where they are, and doesn't even know if they've ever existed. Then there's a request for, number 6, for true and accurate copy of all text messages between her and Dakota Hendren, again dating all the way back to July 1st, 2001, where they discuss the children's mental or physical needs. My client doesn't have them. She doesn't keep messages from Dakota Hendren. She doesn't recall discussing anything about the children's need with Dakota Hendren. And for us to find these, again, we're going to have to contact the service provider. We're going to have to get an IT professional. We're going to get somebody to assist us with this. It is the same for request number 7. These text messages that are years old that we don't even know for sure exist. We can't retrieve what we don't know exists. And again, my client is not in the habit of keeping text messages from her ex-husband or his significant other. Then they asked for emails between my client and Wendy Muska. Wendy Muska, from January 21 to present. My client denies having any emails from in her possession from Wendy Muska, and hasn't communicated with Wendy Muska since the police investigation into Ms. Muska's conduct regarding this case. Request number 11. Please provide a true and accurate copy of a video you made directed at Dakota Hendren claiming Tyler Foote to be an abuser. My client has no idea what this is in reference to. She denies there's any video. And even if there was, Your Honor, this isn't about squabbles between these two women. There's only one issue before the court on motion. And again, that is Tyler Foote's behavior towards his adopted daughter. Request number 12. Please provide a true and accurate copy of a video you made directed toward Dakota Hendren proclaiming Tyler Foote pulled a gun on you. My client doesn't have any recollection of any such video, doesn't know where to look for it, and cannot produce it if it was posted on a social media outlet without the help of an IT professional. And it's the same with request number 13. Again, nothing in this current matter claims that Mr. Foote is abusive towards Ms. Knefelkamp. That's not the issue here. And we don't know why we're being asked to provide evidence that Tyler Foote is abusive towards her when no one is claiming that at all, even remotely, in this particular instance. Request to admit. We're being asked to admit that she made a video directed towards Dakota Hendren proclaiming Tyler Foote to be an abuser. We have no knowledge of any such video. If there one exists, Mr. Foote's going to have to narrow it down for us as to when and where. And my client, again, is not claiming that Tyler Foote is abusive towards her. The claim is plain and simple. She is claiming that Mr. Foote's current behavior poses a present and future harm to his adopted daughter. They're asking us to admit with request number 9 that my client made a video directed towards Dakota Hendren proclaiming Tyler Foote pulled a gun on her. My client doesn't understand what this is concerning. She doesn't have any knowledge of it. And again, her interactions with Mr. Foote aren't at issue here. The only thing at issue here remains Mr. Foote's behavior. So we're asking the court to issue a protective order allowing that discovery in these matters not be had. We answered every other question posed to her. We produced what we could. That's sincerely the best that we can do without an IT professional.
Thank you. Ms. Brown?
Thank you, Judge. Motion that Ms. Knefelkamp filed was to modify. Can you hear me, Judge?
Yes, I can.
Was to modify placement, alleging certain inappropriate behavior.
We can't, you keep, it's feedback.
I'm getting the feedback too.
I'm getting feedback from Ms. Cook, so I'm muting her. So there, now you can go.
Thank you. She files this motion and this affidavit without any professional involvement. The child at issue here has been seeing a counselor. The allegations set forth in the affidavit go directly to abuse, and they go directly to abuse of a particular kind, namely alleged sexual abuse. If someone is going to claim that a child is the victim possibly of sexual abuse, if they're going to claim, as has been done in various reports and pleadings with the court, that the child's personality has changed, that the child's behavior has changed, that they're noticing differences in the child. I would be remiss in my duties, Your Honor, if I didn't look at why, if that's happening, why that might be. Is it because she's exposed to certain things in mom's home? Is she exposed to certain incidences of domestic violence? Is she exposed to certain sexual content? We believe the answer to all of those is yes. And so to go and make a direct link from a child's change in behavior to alleged behaviors by my client without looking at anything in between, well, then I'm not doing my job, Judge. It's not like she's making a claim, not like Miss Neffelkamp is making a claim that Mr. Foote is smoking or doing drugs, and therefore I want content related to sexual posts that she might make. These are directly related to issues she's raising with this child and alleged behaviors of this child. With regard to the discovery, if the answer is, I don't know, then that's the answer, but the remedy is not a protective order. I'm asking for information that goes back to January of 21. That's not even 4 years old. It's very common in family cases to look back 3 to 5 years. I don't think that that is an abnormal request. Interrogatories number 11 and 12 that Attorney Cook just pointed out didn't ask for anything. It asked for a written response. It's an interrogatory. It's not a request for production of document. So if she's going to claim that Mr. Foote is somehow sexually abusing this child, I would like to know if she's put information out into the public domain, which I believe she has, indicating this, and for how long this has been out there. Again, the word abuse is directly in the interrogatory. It's not related to some tangential issue. It's directly related to the issue at hand. It's a question being asked. It didn't ask her to produce anything. Give me your written response to that request. Excuse me, Judge. The same goes with the request to admit. If she doesn't know, or she believes that the request is one that she should deny, then deny it or admit it. But a protective order is not the way to go about it. Almost everything is discoverable, Judge, if it's remotely relevant. Whether or not it is admissible is a different story. It seems that Attorney Cook is trying to make things undiscoverable. Certainly, she has a right to object. She can preserve her objections in her responses. She can raise those objections at the time of the trial, and the court can rule on the relevancy of it and choose to admit it or not. The court can rule on whether something has been satisfactorily answered at a motion to compel, if that is necessary down the road. But discovery is a fishing expedition of sorts. It's to look to see what information might be relevant. To come into this courtroom and say, I'm asking for information about gentlemen who are not witnesses to this case. How does she know they're not witnesses to this case? Maybe I would call them to be if I knew what information they had. And so it's like there's a gate being put up before I can even access the information. I think the petitioner has an obligation to answer it. If the answer is insufficient, that's an issue I can take up with the court later if I choose to. But I think the information is relevant. If you're claiming somebody is an alleged abuser, any information you put out into the public domain is relevant. And it's pretty rich to come into court, Judge, and state that providing this would be embarrassing after you posted it on social media. You posted it in a public domain. You can't really come into court and say, well, I'm too embarrassed to give it to you. You gave it to the public, the general public. So again, Judge, I would ask that, the petitioner answer the interrogatories, the request to admit, and the request for discovery as best that she can. If for whatever reason I feel that I need more information, I have a remedy with this court to seek it in a motion to compel, but a protective order is not the answer.
All right, thank you. Before I ask for any rebuttal, I do have some questions before, again, the rebuttal and before I make any decision. Because I do need to have an understanding to determine if a protective order should be issued or if these are even relevant in the sense of discovery. And as both counsel know, relevance in discovery doesn't take a lot. So first question is, as it relates to request number 8 and emails between Wendy Muska from January 1st to 2021, what does Wendy Muska have to do with this matter and why was there police involvement? And I don't understand. I have no understanding of what the relevance of request number 8.
Wendy Muska is a former, and that's the reason it goes back to 21, had been working with the child in question. She's a therapist. She is a third party to this action, so I could serve third party discovery, but the first way to go about it is to ask for Miss Neffelkamp's records of her communication with Miss Muska, who is the child's therapist, or had been the child's therapist until relatively recently. This individual has extensive knowledge of this case, has extensive knowledge of the repeated CPS reports that Miss Neffelkamp makes against Mr. Foote. So Mr. Foote wouldn't have access or wouldn't have knowledge of Miss Neffelkamp's email communications or text communications with this third party.
Okay, so when Ms. Cook was stating about police involvement as it relates to Wendy Muska, that would be alleged police involvement as it relates to the parties, either Mr. Cook or Ms. Neffelkamp? What's the police involvement as it relates to Wendy Muska?
I guess I would
is
defer
that
to
what you're-
she raised
Is that what you're trying to get at?
Your Honor, my client's child stopped seeing Wendy Muska after Ms. Muska informed the child that there was an open CPS investigation. My client contacted law enforcement. They talked to Ms. Muska. It is our understanding there is an investigation into Ms. Muska's conduct for telling the child that there was an open investigation. And that's when she removed the child from Ms. Muska's counseling sessions on the advice of law enforcement. And just to be clear, Ms. Muska is not a party to this action at all. She's not a third party. At best, she's a witness.
All right, thank you. Now, as I see the other requests, they appear to involve the parties and or Mr. Foote's wife, or as Ms. Cook in her motion to compel discovery, maybe wife, Ms. Jakota Hendren. So I see the relevance with all others. Rebuttal, Ms. Cook?
I don't understand how anyone could think that the individuals mentioned in the first interrogatory are in any way tied to this or would have.
I forgot about that one. Yes. Those other individuals as well that I'm not aware of.
Right. And again,
but I understood that there was, that I understood that there had to have been some relationship between Ms. Kneffelkamp and those individuals just by your answering questions about past failed relationships. So I just put 2 and 2 together to connect that they had to have some type of past relationship with Ms. Kneffelkamp.
I'm not disputing that. However, it's been years, and my client should not have to write an introspection about why her past relationships failed for her ex-husband to approve of. It's truly burdensome emotionally for her. There's no reason for her to relive her past failed relationships. There is no nexus between Tyler Foote's current behavior and Miss Knefelkamp's past failed relationship. There just isn't. There's no allegations from anyone that any of these individuals have any information that would help the court or that they should be dragged into this in any manner. Again, the only issue is Mr. Foote's behavior, not whether my client has had failed relationships.
Is that your only rebuttal?
Yes, Your Honor.
All right. Well, in my review of the discovery that's being requested and the request for a protective order, and in hearing arguments from both Ms. Cook and Ms. Brown, I tend to agree with Ms. Cook as it relates to interrogatories number 9 and 10. However, as it relates to the additional interrogatories and requests for production of documents, I see that they are relevant and could be relevant, and that they can be answered in a way that provides an honest answer. Even if, I mean, Ms. Cook, you stated in your argument answers that are sufficient, at least for the court, as it relates to these requests. And as Ms. Brown indicated and stated, she essentially said the same thing, that especially as it relates to the request to admit that you don't have to flat out deny. You can state, I can neither admit nor deny the truthfulness due to the lack of knowledge or lack of memory. Those are easy to answer, and the court can't see or find that there is any reason for the court to enter a protective order, and that there's no basis for the court to do so. I can't find that there is a reason that, even if there is a great burden to produce documents and such from January 1st, 2021 to present, in the argument and statements that you made to the court, Ms. Cook, the answers provided were sufficient, or at least sufficient to the court. So if this matter comes as a motion to compel from Ms. Brown's side, you answered them, at least satisfactory to the court. And I can't find that these requests would cause shame or anything, or disgrace or anything other to Ms. Knefelkamp, except for interrogatory number 9 and 10. And as it relates to the former therapist, the court does find that that is relevant or could be relevant in this matter. Therefore, the court will strike interrogatories number 9 and 10. The rest must be answered. Do we have another date to come back? Yes, we have January 30th at 9 o'clock. And we are in the large courtroom. I believe we are scheduled for all day, if I'm recalling correctly. Yes, we're scheduled for all day. And so the court will hear all matters at that date and time. Is that correct?
Yes.
Your Honor, we're going to need a hearing on our motion to compel. We simply need a copy of Mr. Foote's marriage certificate, and we need that before January 30th.
I'm denying that. I don't find that relevant. All I need to do is swear Miss Hendren and then ask her if she is his wife, and she faces perjury and contempt of court. We don't need to waste the court's time for them to provide a marriage certificate. Ms. Hendren, please raise your right hand. Do you
Yep.
swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Are you the wife of Tyler Foote?
yes.
What is your wedding date?
Was, what day was it? It was December 31st of, I believe, 2021? No, 2022. I think it was 2020.
2022. Excellent. Thank you so much. We are adjourned. I'll see you January 30th.